Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain the eviction laws in Minnesota and outline some simple steps that landlords can take to initiate an eviction. In this video, we'll talk about what the eviction process looks like, Minnesota laws that determine how evictions are handled, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice. First, what is an eviction? Eviction is the legal process necessary to remove a tenant. It's illegal for a landlord acting alone to change locks on a property or physically remove a tenant from that property, even if the tenant has not paid rent or otherwise violated the lease. If the tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the courts. Keep in mind this is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There is no need to involve a court in this process. In Minnesota, if a tenant fails to pay rent or breaches the terms of a lease in some other way, a landlord can issue what's known as a notice to quit. There are several versions of this form, and each is designed for a different situation. One version is the notice to quit for non-payment of rent. This form orders the tenant to pay unpaid rent immediately or face eviction. In most states, there is a set number of days a landlord must wait before beginning an eviction proceeding. The idea is to allow the tenant time to pay. In Minnesota, there is no grace period. Also, unlike other states in Minnesota, the notice to quit for non-payment of rent doesn't have to be served on the tenant. It only has to be filed in court. Another version is the notice to quit for non-compliance. There is no state statute outlining how long a tenant has to fix an identified problem after being notified about it. So in Minnesota, after receiving a notice to quit, a tenant is advised to fix the problem immediately or risk eviction. There's also a form called a 30-day notice to quit, which is used as a matter of routine to end a month-to-month tenancy. If a landlord and tenant aren't able to reach an agreement and the tenant has not responded appropriately to the notice to quit, the landlord can bring an eviction action. This can be done by filing several forms in the district court. The first form is the eviction action complaint, which outlines the nature of the lease violation. A copy of the signed complaint must be made for each tenant named on the complaint. The landlord should also keep a copy. The complaint, a copy of the lease agreement, and a copy of the notice to quit must be filed with the court administrator. Following the filing of the complaint, the court will create a summons. This is a written notice to the tenant that a legal action has been filed and a hearing will take place in court on a specific date. It states that the tenant's only means of protesting the eviction is to appear in court on the date of the hearing. Once the complaint and summons have been filed in court, the landlord must have the document served on the tenant. The landlord cannot be the person who serves them. A neutral person should be used to deliver these forms, or otherwise a process server or the sheriff. If the tenant cannot be found in the county and personal service has been attempted at least twice on different days, with one of the attempts having been made between 6 and 10 p.m., then the documents can be mailed via certified mail. The complaint and summons must be served on the tenant at least 7 days before the hearing date. They cannot be served on a legal holiday. An affidavit of service which confirms the papers were served should be filed with the court at least 3 days before the hearing. Weekends and holidays do not count as days. The tenant has the right to file a counterclaim via a form called an answer before the trial date. The document served on the tenant should indicate that the tenant has the right to pay back any rent owed during the eviction process and will be allowed to stay if payments leave the tenant up to date on rent. Both parties must attend the hearing. If the tenant does not appear in court, the judge will rule in the landlord's favor. If the tenant is ordered to vacate the property and fails to do so, the landlord may apply for an order called a writ of recovery of premises and order to vacate. When signed, this document authorizes a sheriff to forcibly remove the tenant and the tenant's possessions from the premises. We've got everything you need to get eviction proceedings in Minnesota going. You can access everything from eviction notices to court documents, all at the link below. And don't forget to subscribe to see more instructional videos on other important topics.